Okay, part two, where we left off before my phone started ringing. International law, Article 15, everyone has the right to nationality. No one shall be arbitrarily deprived of his nationality, nor deprived or denied the right to change his nationality. The rights of indigenous people, it part one, Article 5. Every indigenous individual has the right to a nationality. Treaty of Peace and Friendship between Morocco and the United States, the land you're standing on. United States is a shell corporation created to administer the estate of the heirs, who are the true natural and divine people of the land, the Aboriginal and Indigenous people. 1787 through 1836. Treaty of Marrakesh, supreme law of the land. United States Executive Order 1310. The implementation of human rights treaties. Now, the jurisdiction falls up under this article in clause, which is the second clause of the United States Constitution, clause 2. The Constitution and the laws of the United States, which shall be made in pursuance thereof, all treaties made, or which shall be made under the authority of the United States Governmental Services Corporation, shall be the supreme law of the land. And the judges in every state shall be bound thereby, whereby they have taken an oath, not to be wavered by the bar administration. And they shall denounce the bar. I added that in there because that's what they are supposed to do. They're not supposed to be bar members and then be on there pretending to be a judge when they're a lawyer and a judge at the same time. It's conflict of interest. Okay, anything in the Constitution or the laws of any state to the contrary, notwithstanding. Okay, now comes the alleged accused and I would say petitioner, which I may change that word, Selassie Wali Bey, in propria persona, a natural person, and not a 14th Amendment corporate person, nor a nom de guerre construct, whose substantial rights have been violated and abridged, standing squarely in propria persona, sejuris, and upon my birthright nobility, being in full life duly affirmed under allegiance to my Moorish American nation. Organic, right law, Republican form of government in North America, and under affirmation and oath to the 5 principles of light, being love, truth, peace, freedom, and justice, which is the isonomy, the foundation, the principles, and being part and parcel of the organic said government, do squarely affirm and attest to the truth. I am appearing specially and not generally to demand for this court to have the following alleged tickets, suits, summons, citations, misrepresented bills of exchange, numbered 132203. Ticket numbers as a bookend number for false rant of war for POW held in ransom one day in their municipal corporation. And the unlawful and culpable proceedings, unlawful war rants, etc., related to it, then declared as vacated, as void, as lawless ticket, suit, summons, citation, misrepresented, bill of attainder, bill of exchange, for the court's lack of subject matter jurisdiction, the lack of personam jurisdiction, the lack of due process, and the lack of an injured party, corpus delicti. And that the state does not, nor does any of its subordinate corporate entities or agents have any lawful right or lawful authority to transfer or convert the exercise of a right into a crime, nor does the state possess such authority, nor does any of its franchise corporate entities, agents, or officers possess the lawful right or authority to punish, to incriminate, or to exchange anyone or to charge anyone with a crime, absent of a true bill and indictment by a grand jury, or to injure or to intimidate or to threaten any natural person, people, or citizens for enjoying or exercising any substantive right or any other injured secured right exercised by them and secured for the people by the established law of the land. Now this gets deep. If you're still listening, you might accidentally learn your rights if you pay attention. As I said, reserving all rights secured for the natural person, people, and citizens under the supreme law of the land, and reserving all natural rights, divine rights, substantive rights, liberties, privileges, and immunities reserved for the people and citizens secured under the authority of the Constitution for the United States Republic of North America, and by international law, to which the judges of every state, the officers of this court, all state agents, agencies, and contractors, officers, and or representatives of or for New Jersey and any other all Texas. Oh, I got it. Any officers of the foreign state of Texas corporate entity are bound to uphold it, to support and respect by law and by oath the supreme law. It is further stated for the record that the state's hired officers, employees, agents, entities being the same in partnership are bound to support and uphold the Constitution for the United States Republic, and that the unlawful theft under color of law of my personal liberties, property, rights, immunities, person, or property being held, abridged, or arrested by any official, persons, or agents contracted by the officers of Gregg County Court, Incorporated, or by its employees for monetary ransom or legal extortion by virtue of voided due process actions, or for any other extorting or colorable purposes is a violation of the substantive rights of myself, a crime against the sacred trust of the natural people, a violation of fiduciary duty, an abandonment of office, a perjury of oath, and repugnant to the Constitution. These conspired acts of collusion and practices of abusing authority or by color offici. Tickets, suits, summons, citations, etc. are all bills of exchange. Anyone who is served with these implied in law contract instruments should be made cognizant of having the right to be served the original copy of the said instrument and their right to sign the original instrument and pay it on the spot. And if the police officers or agents denies the recipient the capacity to do so, then the ticket, citation, bills of exchange are voided, as the process is unlawful in its nature in the first instance. The natural person being effectively imposed with these instruments are systematically denied the ability to receive the original copy of these instruments, bills of exchange, presentments, and thus the proper service principle of due process is colored. When they say colored, that means it's fake, it's fraud, pretense. The recipient is thus disabled to return the original instruments, presentments, bills of exchange to the ensuing drawer, appearing to not have been willing to accept the original and thus honor the bills. At the instance of this issuance of it, then this contrived violation of due process is law is ultimately manifest in court with an administrative ministerial court decision or conviction made or levied against the unsuspecting so-called violator. This act is a supreme violation against Article 3 of the Constitution and is void of law, essentially a nullity. So with that being said, you can seek remedy, and as I will seek remedy. You say, is it reasonable? It is reasonable for any natural person or citizens to assume that the municipal court would recognize such improper service as being void of law, and that such improper service, as prescribed and defined under the Bills of Exchange Act, constitutes misrepresentation and negative misprision. In order for a bill of exchange or presentment, which tickets, citations, or summons or all constitute to have and possess lawful validity, the drawer has to have and has to possess the authority and knowledge to create it. Police officers establishing for themselves the position of drawers and any other persons or agents who issue such quasi-judicial instruments are aware of the fact of law concerning these instruments and their violation of due process nature. Policemen and other municipal agents, drawers, have been and are continually violating the natural people and citizens. They create the conditions that falsely establish that the natural person and citizens to whom the drawer, policemen, or agents issue the tickets, suits, summons, citations, misrepresented bills of exchange, go into dishonor and are thus convicted in court by default and dishonor by way of misrepresented process. This causes the recipients of such instruments to appear under threat, duress, coercion before the non-Article 3 municipal courts, which are fraudulent tribunals. As a drawee in dishonor, the court officers are well aware of this constructed, faulty process and are aware that the recipient of such bills of exchange instruments should be given the original copy of the ticket, suits, summons, and citations, and bill of exchange, in order that the unsuspecting recipient may have the opportunity to return or satisfy or honor the payment demand of prescribed and adjudged payment to the drawer. Policeman, executing witness, accuser being the creator of and issuer of that bill of exchange instrument. Police are agents who issue such instruments and address them to others are, by legal definition, the drawer. The possession of weapons by anti-constitution officer, policemen, and other corporate agents and their practiced enforcement of color of law and the applying of and using a contemptuous method and the issuing of misrepresented constructs, which are instruments they use to manipulate and to subvert due process of their practice, which they abrogate, and the abrogation of and their suppression of the Bill of Rights, which no man shall be held in lieu of a debt, and their addressing of other violations made by or initiated by the state or by its franchise officers, agents, agencies have been and are used and initiated to rob, to threaten, to intimidate, or to injure the natural people and citizens. All of these acts are violations of the established law of Supreme Court of the United States under the command of the Republican form of government, as established under the Constitution for the United States, has ruled that such actions, laws, or ordinances, or on the part of the state, its officers, and its agents are a color of law and are unconstitutional. These collective colored offici act and laws initiated under color of authority are in violation of Title 18, Chapter 13, subsections 241 and 242, the United States Codes of Law, and are also in violation of Title 42 under the color of law for the United States of America. Supreme law of the land. The senators and representatives before mentioned and the members of the several state legislation or all executive, judicial officers, both of the United States, of the several states, shall be bound by oath, affirmation, and to support this Constitution. But no religious test shall be required as a qualification by any office or public trust under the United States. And here we have the Supreme Court stare decisis, which are the law of the land, and the rights to travel, the right to travel in the right of mode of conveyance, and which is the same one that is identified right here on this document that I presented before I was kidnapped. It's the same one, as you can see right here. State versus Olmsted. The right to park or travel is part of the liberty of which the natural person, citizen, cannot be deprived without due process of law under the Fifth Amendment of the United States Constitution. That's Kent versus Doles. The state is prohibited from violating the substantive rights, and so on and so forth. And this is what will be presented, which should be an open and shut case, seeing how we have all the case law and the obligation of the state courts, the United States Supreme Court, state courts, like federal courts, have a constitutional obligation to safeguard personal liberty and to uphold federal law. But the Texas state think the federal is not an authority to them, but they supposed to uphold federal law. They put so many of these guys in office that don't know the law, and they're making up stuff as they go along. We need to have a lot of impeachments going on right now. Therefore, the officers of these townships shall be held accountable under the United States Codes of Law, Title 18, Chapter 13, subsection 242 and 241 and 242. Now listen to this. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise and enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise, in uniform, on the highwaymen, highway troopers, highway patrol, or on the premises of another with the intent to prevent or hinder his free exercise or enjoyment of any right, privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or attempt to kidnap, aggravated sexual abuse, and any other attempt to commit aggravated sexual abuse or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, or any be sentenced to death. This is how serious this is. Whoever on the color of any law, statute, ordinance, regulation, or custom willingly suggests any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or the laws of the United States, or the different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race, then or prescribed for the punishment of citizens shall be fined under this title, or imprisoned not more than 1 year, or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of dangerous weapons, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or for life, or both, or may be sentenced to death. This is serious. Now, every person or city, state, or government official who, under color of law, deprives any legal citizen their legal rights or immunities and is subject to civil and or criminal penalty pursuant to United States Code of Law, Title 18, Part 1, Chapter 13, Subsection 241 and Subsection 242, the ultra virus statutes do not protect such violating person from prosecution, or individuals, and such violators are subject to $10,000 fine and or prison. $10,000 at that particular time was a lot of money, but nowadays $10,000 is not the equivalent of the injury for that particular part. So I'm pretty sure they make the necessary adjustments to accommodate those being violated and that seek remedy. Notice the agent is notice the principle. By binding official oath, an oath of ethics taken by all present persons and any past person formerly holding a public trust or public office, and by virtue of that trust, or obligated under the authority of the United States Republic, and by the supreme law of the land, and not abridged, not to dishonor, but to respect and protect the substantive rights, liberties, and immunities of the people. The obligations of this official holding seats, of these officials holding seats of government administration, or occupying positions of authority, it still stands. The void alleged tickets, suits, summons, citations, misrepresented bills of exchange as reason for vacating and granting relief. Relief may be granted where the tickets, suits, summons, citations, misrepresented bills of exchange, in the number 132203, or any actions or orders arising from their construction is void because the court lacked jurisdiction over the subject matter, lacked personal jurisdiction over the parties. In addition, misrepresentation and a denial of due process of law. Accusing parties, police, private security guards, which they are, officers of the court, etc., acted in some manner inconsistent with constitutional constraints and contrary to the constitutional secured due process, or otherwise acted beyond the delegated powers granted to them under the supreme law of the land, when evidence, a motion, or affidavit challenges a ticket, suit, summons, citation, bills, exchange as void, and in the inferior court, and district court lacks discretion in accordance with established law of the land, I move that the judge, prosecutor of this court make void and vacate the unconscionable suits, tickets, instruments, misrepresented bills of exchange as the improper presentments are contrary to and repugnant to the Constitution, being a violation against secure due process rights, and contrary to and repugnant to oath of ethics, oath of office, official oaths, fiduciary duties, and foreign to right law principles. Greene County Municipal Courts and its corporate contracted officers, agents, and personnel are cited for unlawfully using the public trust to transfer or convert a right into a crime under a color of law, under a color of authority, and under a color of right. I, Selassie Bey, by law, shall be compensated in the amount of $50 million for my economic losses by way of denationalization, public humiliation placed on social media and plastered all over the world as defamation of character, infringements upon my liberties, and being kidnapped, theft of my personal property, my car, my BMW, extorted in lieu to get my motor carriage back with my plate identification, in which I shall enter in just a second, and for the mental anguish imposed upon me by being forced under threat to answer to culpable actions caused by agents, persons, or concurred in the conspiring, agreed, organized violation of RICO laws, actions to cause my private divine rights, civil liberties, pursuit of happiness, security of personal liberty and or property, etc., to be infringed upon, confiscated, arrested, kidnapped, or restrained in a manner by any acts, actions, and or processes that in any respect violate these amendments. And I stated the amendments here. All of them.